So this is Diesel for We the People News, and doing a little bit of investigation on this word here. And I'm not an attorney, don't care to be an attorney. This is just a learning deal. Just never look straight forward. Always look around you and try to keep the outside forces against you. So they don't enter to your circle. Let's listen to this right here. And there's been a couple of videos since I've heard of this word many times over my lifetime, and been a jury, and a couple of times, this has happened to me, but I never really looked it up and never had to use it, other than a couple of times. So this kind of intrigued me when I went to the bank and said that they don't need a warrant, that they needed to subpoena me, or subpoena my stuff. So here's a little idea. Let's check out this video and see what they had to say.
A subpoena is a writ issued by a government agency, most often a court, to compel testimony by a witness or production of evidence under a penalty for failure. There are two common types of subpoena. 1. Subpoena ad testificandum orders a person to testify before the ordering authority or face punishment. The subpoena can also request the testimony to be given by phone or in person. 2. Subpoena duces tecum orders a person or organization to bring physical evidence before the ordering authority or face punishment. This is often used for requests to mail copies of documents to the requesting party or directly to court. The term subpoena is from the Middle English subpoena and the Latin phrase subpoena, meaning under penalty. It is also spelled subpoena. The subpoena has its source in English common law, and it is now used almost with universal application throughout the English common law world. John Waltham, Bishop of Salisbury, is said to have created the writ of subpoena in the reign of Richard II. However...
Okay, reign of Richard II. Okay, at that particular time in history, what I guess he did is use this word to bypass some of the safeguards against the people. I don't know the full history of this word, like I said before, but the king was not a good guy, and he was always trying to sucker people to his benefit. And if it was under common law, he probably most likely used this word to benefit the government, which I can see, okay? How does the subpoena actually help we the people? It don't. When they do a subpoena on you, they put you under bondage, okay? For what little I've studied on this still, again, I'm not an attorney, don't care to be an attorney. This is just learning purposes only. And I may be 100% wrong. However, I may be 100% right. Never look forward. Always straightforward. Always look around you. So keep all these things and learn from it and see what the cause and effect would be against you. Everything the government does is for against the people, never for the people. So I had to go under the impression this benefits the government, mainly because they're bypassing the warrant. Let's go ahead and proceed forward, and this helped the king out at the time.
For civil proceedings in England and Wales, it is now described as a witness summons, As part of reforms to replace Latin terms with English terms which are easier to understand, subpoenas are usually issued by the clerk of the court in the name of the judge presiding over the case. Additionally, court...
Think about that for a second, y'all. It's the clerk that does the ordering, not even the judge. So how did this clerk actually have authority over you instead of the judge? Let's forget what all I know in the past and videos I talked about. The question is, how did that clerk get authority over you instead of a judge?
Rules may permit lawyers to issue subpoenas themselves in their capacity as officers of the court. Typically, subpoenas are issued in blank, and it is the responsibility of the lawyer representing the plaintiff or defendant on whose behalf the testimony is to be given to serve the subpoena on the witness. If a witness is reluctant to testify, then the personal service of subpoena is usually required with proof of service by non-party server. The subpoena will usually be on the
Okay, by a non-party server. Alright. Just for argument's sake. All lawyers go by hearsay anyway. And then they're going to go by a third party to go to a third party to drag in a third party.
letterhead of the court where the case is filed, name the parties to the case, and be addressed by name to the person whose testimony is being sought. It will contain the language "you are hereby commanded to report in person to the clerk of this court" or similar, describing the specific location, scheduled date and time of the appearance. Some issuing jurisdictions include an admonishment advising the subject of the criminal penalty for...
Okay, jurisdiction, right? Alright, and again, I'm not an attorney. But if I got one of these again, and my days of knowledge, okay, it's an order, but it's still a contract. So I would have to actually ask for a squash with a Q, not with the whatever the letter is. And then an affidavit and notice, and then a couple of, not affidavit notice, but affidavit of standing, and then a couple of notices to challenge this so I do not enter jurisdiction, okay? Like I said on the other videos, our major problem we have is we voluntarily enter jurisdiction. So in short, the summons is basically giving you an order, but it's an order of contract. Once you receive this and you sign for it, you gave them jurisdiction, so this summons will go ahead and put you in jurisdiction of the courts. You had to actually, most likely, as of this point, what little I know of this, again, do your own research. I'm not an attorney, but I would file, void, contract denied, refuse to contract, and send it back to them. Because it's going to be still a form of a one-sided contract. And if you sign it, then you entered the contract. So what I'm doing is stopping the contract before it puts me in jurisdiction. Okay? Again, it's a learning video. Don't take my advice, just do your own research.
Failure to comply with a subpoena, and reminding him or her not to leave the court facilities until excused by a competent authority. In some situations, the person having to testify or produce
a competent authority. So, if you know anything in court at all, no lawyers, no judges, no clerks are competent. They're playing stupid little games with you, and enforcing you into jurisdiction without your knowledge, and now you got to ask permission. So, yeah, no, I'm not going to play that.
Documents is paid. Proso litigants who represent themselves, unlike lawyers, must ask a court clerk to officially issue them subpoena forms when they need to call witnesses by phone or in person, or when they need to officially request documents to be sent to them and/or directly to court. Any documents that have not been subpoenaed to court or verified by a witness may be dismissed by the opposite party as hearsay, unless accepted by hearsay rules or permitted by the judge. If the witness is called via long-distance phone call, then the requesting party is responsible for initiating the call and providing a payment with a prepaid phone card. Some states, as is the case in Florida, require the subpoenaing party to first file a notice of intent to serve subpoena, or a notice of production from non-party 10 days prior to issuing the subpoena, so that the other party may have ample time to file any objections. Also, the party being subpoenaed has the right to object to the issuance of the subpoena if it is for an improper purpose, such as subpoenaing records that have no relevance to the proceedings, or subpoenaing persons who would have no evidence to present, or subpoenaing records or testimony that is confidential or privileged. In New South Wales, Australia, a court may set aside the whole, or part of, a subpoena on the basis that it is a fishing expedition. In Lowry v.
Okay, and you guys heard me talk about this in other videos. So explain to me how we actually have same laws here in the United States as other countries, and we still call our country a free country. Explain that, people.
Insurance Australia Limited, the NSW Court of Appeal held that where documents requested in the schedule of a subpoena are deemed to have no relevance to the proceedings in dispute, the subpoena may be set aside as it has no legitimate forensic purpose. It was also held that it was not the role of the court to redraft the subpoena and narrow its scope to those issues in dispute.
Yeah, that's one video to kind of give you guys an idea. And I know I sat here and challenged the way they was talking about this. But it seems to me that there's a lot of third parties involved in this. And where's the first-hand knowledge of the fact when there's too many people being third parties? All right? That goes within the guidelines of a third party. Can be hearsay. So I don't have first-hand knowledge of this type of word. So don't just take it by facts or anything like that. Again, I'm not an attorney. You may want to talk to an attorney. But this is my opinion and not facts. I'm still going to do some research because I still don't like the simple fact they can do a subpoena on my personal effects to a bank without a warrant. So anyway, it is what it is, but at least, I'm not looking straight forward. I'm investigating what the cause and effect is when I bank with a bank. So this is decent for We the People News. Sit and think about these, y'all. You wonder why we have no rights? Words like this is pulling you away from the Constitution and putting you into some other jurisdiction. And I call it a foreign jurisdiction, which it is. It's a foreign jurisdiction. If it's not a foreign jurisdiction, why did it come from overseas and entered here? Why are they using the same word in other countries? Alrighty? So something to think about, y'all. Till next time. Bye.